I have personally gotten to know them through my venture with my son with type 1 diabetes, and I've definitely recommended them to a handful of my patients. Today we're joined by Amanda Selogie and Vickie Brett. Thank you for being here.
Thank you for having us.
I'm going to give a brief background, and then we're going to talk about your child in the school system if you have any special needs. Amanda Selogie, received a degree in child and adolescent development, specializing in education from California State University, Northridge, and a Juris Doctorate from Whittier Law School. While at Whittier Law School, Amanda was a fellow in the prestigious Center for Children's Rights Fellowship Program, the chief editor of the Journal of Child and Family Advocacy, and served in a pro bono special education legal clinic. Amanda co-founded a boutique civil rights litigation firm, Selogie and Brett, specializing in specific civil rights issues on behalf of children living with special needs, and co-founded the Inclusive Education Project, a legal advocacy 501c3 nonprofit organization focused on educating families on their legal rights to their child's education and providing pro bono legal aid to low-income families in California. Amanda is currently the supervising attorney for UCI Law School's Education Rights Pro Bono Project and works with the Orange County Child Care and Development Planning Council. In her personal time, she serves as a coach to the AYSO program for players living with disabilities and has established a program to mainstream these children with other teams. Amanda's career did not begin, nor has it continued, as a focus just on the practice of law, but as a tool to advocate for those who cannot advocate for themselves, to fight for all children who have a voice. She believes that children should be recognized and supported by the abilities and the facets of their being that makes them who they are and makes them special, rather than what their disabilities may be. She focuses her practice and her work on each individual child, on the child first, who they are, and that each one deserves the opportunity for an equal education. She takes that passion with her to each Iep meeting she attends, each case she fights for, and for every family that walks through her office doors. Thank you for all you do. I got a little bit of goosebumps and choked up because I know it's true. Vickie Brett attended UC Riverside and received a Bachelor of Arts in Political Science with a minor in philosophy before becoming a very active Whittier Law School student and alumnus. Through the law firm, Selogie and Brett, Vickie is committed to which has now merged with the 501c nonprofit IEP. The Inclusive Education Project is their new company. Vickie is committed to strengthening her clients who come to her disheartened and beaten down by the current education system. Because Vickie is bilingual, she represents and empowers many monolingual Spanish-speaking families living in Southern California. Moreover, she's a dedicated pro bono attorney for Public Law Center, the Alliance for Children's Rights, and the Superior Court of Los Angeles' Juvenile and Dependency 317 panel. Most recently, Vickie became a supervisor for the UCI Law School's pro bono special education law project. Vickie's commitment to community service is embodied in the legal advocacy 501c3 nonprofit she co-founded. The Inclusive Education Project focuses on educating families about the legal rights their children living with special needs are entitled to, and it also provides pro bono legal aid to low-income families in California. I decided to share all of your past because it's very heartwarming, because your work is hard work helping families with these big districts and getting their children the education that they need. So we'll jump into our first question, and this is live. So if people share with me their questions, I'll try to interject appropriately. So what is the difference between an IEP plan and a 504 plan? And maybe you can just define both of them for us. Whichever of you wants to take that one is great.
usually Amanda jumps in, so I always wait in the wings. I'll go with the IEP, and then Amanda, you want to talk about 504. So an IEP, we love to talk in acronyms in special education. So IEP actually stands for Individualized Education Plan or Program, and it's a highly specialized plan of instruction, which may include accommodations, modifications, present levels of the child, goals that the child will be working on feasibly within a year, and then whatever supports and services that will help the child actually achieve those goals. So it's a really specific program. And then Amanda will talk about 504, and then we can kind of talk about the differences.
Yeah, so a 504 plan is going to be similar in that accommodations and sometimes goals are included that relate to the student's disability. However, it's more on the more limited side. It's going to provide usually just those accommodations and service level supports, not the full specialized instruction, related services that you might get from an IEP. Typically, we see 504 plans with students who have more medical side disabilities. If it's sometimes a temporary condition, oftentimes we have a 504 plan. But I'd say a big difference between the two is going to be eligibility. So who needs specialized instruction? A 504 plan is going to have a different eligibility criteria than an IEP. And so typically when a student needs specialized instruction, you're going to fall to the side of the IEP versus accommodations when we think about access to instruction. So whether it's physical access, so needing a wheelchair ramp or needing interpretation for a student who is blind or deaf, if all we're talking about is helping them gain access to that instruction, a lot of times we're looking at accommodations, we're looking at a 504 plan versus actually modifying or accommodating more on the level of their entire kind of day-to-day in school.
And Section 504 is of the Rehabilitation Act, whereas an IEP is created under the Individuals with Disabilities in Education Act, IDEA. And, you know, typically the main difference that a lot of people say is that 504 protects from discrimination, whereas the IEPs are a right for a child that has been identified with unique needs, right, to be provided with a free and appropriate public education. So under an IEP, we all know what free means. We all know what, public education, where our bread and butter is essentially why we have jobs is what is appropriate. Whereas, you may see those buzzwords in Section 504, but just a really simple way that we sometimes describe the difference is if your child is in a wheelchair and there are no wheelchair ramps, as Amanda had alluded to, that is preventing access of your child in a wheelchair from accessing their education. And so that would be discrimination and would fall under Section 504. Whereas the IEP is more related to, okay, what are the unique needs of this child and how can the IEP be tailored to meet their unique needs?
And when we look at the word accommodation, accommodations can mean a lot of different things, from that wheelchair ramp to having an interpreter to having a special space for taking tests. Accommodations can mean a number of different things, and that's where oftentimes there gets to be a lot of confusion between whether a child should be on an IEP or a 504, because schools often will say, well, we can do all of this on a 504. And a lot of times parents get into the rut of not really knowing what the difference is, being told there's not much of a difference. So, okay, we'll just go with the 504. But one of the biggest differences is the rights and protections you have. Because an IEP and a 504 are created under different laws, the IDEA, the Individuals with Disabilities Education Act, governs IEPs, whereas Section 504, the Rehabilitation Act, governs 504 plans. Each law provides a different protection and a different set of rights. So where an IEP is required to be met, an IEP team is required to be met every single year and review goals and objectives and services and ensure that free, appropriate public education, that FAPE. 504 plans, while they should be reviewed every year, there's not as much stringent requirements. So a parent with an IEP has the right to ask for an IEP meeting anytime they want throughout the year. They have more rights to timelines on when students should be assessed, when they should be reassessed, when a meeting is meant to be there, and the type of meaningful education they're entitled to under an IEP is going to be different than a 504, where the requirements are a little bit more loosey-goosey. They're not as stringent. And the way that we enforce each of these plans is also different. Generally, IEPs are enforced through state courts versus 504 plans have to go through the federal courts. So there's a number of differences, but one of the things we'd like to really make sure parents understand is that your rights are going to be different under each. So the question isn't generally, well, can we do these accommodations under a 504 plan? Because sometimes we can do it under both. It's is the student eligible? If a student is eligible under an IEP, they should fall under an IEP because those rights and protections are there for them and for the parents.
So a couple questions about all of this. How often is a student eligible for both? It would seem like it'd be quite common that they could do both. Is that more rare?
Yeah. Oh, go ahead. Oh, I was just going to say, typically what will end up happening is there's a course of evaluation. So we were able to talk to the school psychologist, and they typically make a decision of either or. There has been the rare occurrence that they would do both, but because some of the testing does overlap, for instance, looking at the child's IQ and things like that. But more often than not, it's like, okay, let's either do the 504 evaluation, and then if we have still more questions, maybe we need to do the IEP evaluation. Or with us, we like to let's just do the IEP evaluations because they're more thorough at times. You're going to have, everybody on the team. If it's speech and language that we have to look into, occupational therapy, physical therapy, there's just a lot more that we can pull from. But yes, it would seem to be that a lot of times they overlap. One thing with the 504 as well is that there's typically medical or some type of documentation of the physical impairment or the mental impairment. With an IEP, you don't necessarily need to have the ADHD diagnoses, right? Or the autism diagnoses. It's okay if you do. It's something you should share, absolutely, but it's not a requirement.
And I would say that the threshold for becoming eligible for a 504 is substantially lower than the threshold for an IEP. So almost every student who's eligible for an IEP is likely to be eligible under a 504 as well. And that's where the confusion comes in, is that a 504 team may come in and say, well, this student's eligible for a 504, let's just do that. And if a parent thinks about that on the surface and just agrees with it, the problem may come down the line where the child is not being supported enough by the 504, and the team never even considered an IEP. And, we want to make sure that we're assessing the child thoroughly. And so like Vickie alluded to, the assessments are going to be a little bit different. You're going to have a more thorough assessment with an IEP. And so the threshold for an IEP to do an assessment is there a suspicion of a disability? Not, is there a disability? Not, is the child doing poorly? Not, is the child failing? That's not the standard. The standard is there a suspicion, and that suspicion can come from anybody. Can come from the parent, can come from a physician, it can come from a soccer coach, it can come from anybody working with that child who has a suspicion of a disability. You have an obligation to assess for an IEP and determine eligibility. And if you go through all of that and it doesn't seem the child is eligible, then that's when you should consider, maybe we look at a 504. But we do see more often than not, it's the flip, that we look at 504 first, and we often then don't have enough information.
And these plans, are they are all schools held accountable to them, or just schools that get funding from the federal government and state government?
Oh, you answered that question. Yes, so the latter. Because these are federal laws, the schools that receive public funding. So sometimes people say, well, what about charter schools? Charter schools receive public funding. I know that sometimes they operate or advertise like they're a private school, and they have many benefits, but they also still receive public funding. So that is who needs to abide by these laws.
And oftentimes, private schools seem like they're fully private, but if they receive federal funds, even a penny, then they are subject to these laws. Now, one thing that's kind of come into play in the last few years has been the COVID funding. There have been private schools that have accepted COVID funding. That's federal dollars, and so that could make them liable. Now, the COVID funding is temporary, so there is that fine line, but we see, we talked about the IDEA and Section 504, which are the two main laws that we are governed under with special education. The main difference for private schools is there's also the Americans with Disabilities Act, the ADA. That is something that they have to abide by, which protects against discrimination. So the main thing that we look at with private schools is there discrimination going on with regards to the student's disability? That can come into play, certainly.
So ADA is a civil rights law that has to be upheld in any scenario, in any location in the United States. Is that a good way to understand it? The American with Disabilities Act is going to be across the board in education or outside of education?
Yeah, it's across the board with both public and private institutions. And that's primarily with regards to the discrimination aspect. So we see sometimes the ADA coming into play with regards to access to facilities. That part is with public spaces. So anywhere that the general public has access to. So like a restaurant, we see it coming up a lot with accessibility to restrooms, or wheelchair ramps into restaurants. We see a lot of lawsuits that come up because of that. That doesn't necessarily apply the same way with private schools because it's not a place of public. But when we look at discrimination, we are looking across the board, a prohibition against discrimination for disability. The hardest thing is that proving discrimination based on disability is very difficult, and the standard for proving it is very difficult. So it's not a big source of like litigation or lawsuits for private schools very often because it's very difficult to prove. So we do see private schools that get into trouble more so maybe in social media and that sort of thing, and we do have cases that happen. But it's not along the same lines of what is it regarding their education that we're looking at? Is the school obligated to provide a different education? Mostly we're looking at public schools with that.
And so Section 504 was before the ADA, and the ADA came really to like fill in some gaps. Primarily, you're looking at Section 504 for that discrimination in the public school settings. And then the ADA tried to cover a little bit of what you would see public and private.
I was able to share a link for learning about the IEP, but maybe if you guys later can share with me a good reference for the 504 plan, I can share that with people. I want to comment that I wasn't sure whether I wanted my son to be in a private or public school. And of course, maybe just it was less than a year before kindergarten, he has type 1 diabetes. And for those who don't know, he's constantly at risk of having a hypoglycemic shock event, especially at his age. So somebody needs to be with him 24/7 to make sure that's not happening. Well, it wasn't until I contacted you guys that I realized that we have much better ability in the public school to get what he needs for a proper education, because otherwise he'd be out of the class so often, and it would really affect his relationship with school and his ability to learn. So there's so much to learn about these laws and what might be the right spot for your child. Private, I have seen some great private schools though be accommodating.
Yeah,
Absolutely.
I think when there was a time when the Department of Education under Betsy DeVos was talking about vouchers, and we were thinking, oh my goodness, you're going to get a voucher and you can send your child to public or private school, which we were against the vouchers because more money is in the public schools for our kiddos with unique needs. So we did see 4 or 5 years ago some private schools kind of amp up their, we kind of have like student team meetings, or they would try, but the reality of that, now that those vouchers weren't going to come to fruition, is sad. We are seeing a lot of bullying of those kiddos that went there because the parents thought that was going to happen. And, it's just, you got to weigh it, weigh all those options.
Yeah. And it's going to be school to school. I mean, just like public schools, there are some private schools out there that have phenomenal programs for students with disabilities. And so when we talk about IEPs and 504s in the public school system, we're talking about what is obligated to be provided by these schools, but that doesn't prevent a private school from doing the same thing. We have private schools that follow IEPs to a T. Students go to their district, they get an IEP based on an assessment, they go to a private school, and the private school says, we have no problem. We have a special education program. We have a special ed teacher that's going to provide these minutes. But not all schools are like that. And unfortunately, there's no way to enforce that. So if you go to a private school and the school is giving you services and they have a program that is designed that seems like it's great for your child, but administration changes, the program changes, they lose funding, they shift around funding, there's no guarantee that program is going to be there the next year. And there's not really an enforcement mechanism for you to say, no, but wait, my child is benefiting from it. So that's generally when we look at the pros and cons, we always are looking at that. Public school, they're required to follow the IEP. Private school, they're not. They may provide you services, they may not. There's just not that guarantee or enforcement. But, just like public schools, private schools have good and bad, and in the middle.
Yeah. I want to take us to our next point, which is a nice transition from what we're talking about. Once you do suspect you need an IEP or a 504, what are some tips you would recommend parents go through, some pointers to go through before or learning about how to address the school, or what do they do first? And in this conversation, I'd like to ask your perspective, and you're not trained for special education needs as far as what the assessments look like, those neuropsych assessments at the school versus public, but maybe you could touch on that, because I see such more thorough, in-depth reports when they do a private report, and there's pros and cons of doing that. But I understand people have shared those and the school will just accept those, or their report will look very similar and mirror a private report of what these assessments say this child needs. So maybe you could talk about that too. And what would you do, the schools first, or do yours first, or do you share that you have one? So
I think this is important. It's important to make a distinction here. So while there are 13 eligibility categories for a child to receive an IEP, it is not medically based. So what we often see is when a parent goes to a neuropsychologist or psychiatrist, or any of these number of people that are able to diagnose a child, for instance, with autism, a school will say, well, we don't diagnose. We don't do that, right? Which is fine. And yes, that is technically true. But they cannot ignore that child's diagnoses. It is a unique circumstance of the child, and it's something that they have to take into consideration. Now, what I often see is that the child may fall under the eligibility category of other health impairment or specific learning disability, but has autism. And the parent's like, well, I want autism. I want it to reflect autism. What they're looking at is what disability, what unique need is impacting the child's access, learning. What is impeding the child from being able to sit in the general education classroom? And I think that is something that if you can go and get the private assessments, absolutely yes. Do we use them when we file complaints? Absolutely yes. Is it going to be super thorough? Yes. But the school psychologists, the testing that they do, oftentimes they can read, it's numbers, and the interpretation is what is skewed at times, that we would argue, right? Whereas if we go to a private person, they're going to give us a lot more information behind that. So I wanted to make that distinction because we see that a lot.
Yeah, I would say the timing isn't as important. Like, you're not going to screw anything up if you go and get your private assessment first, or you have a district assessment first. A lot of times the main difference between the two is the location of the assessment. So if you go and get your child assessed before they turn 3, so before 5, right, before they're in the public school, or it's just a private assessment outside of school, generally that testing is not done in the school setting. It's done in the assessor's office. If your student is already in a public school, a neuropsych typically will do some observations, have some rating scales done by the teachers. But it is not always the case. A lot of times parents have it completely separate. So what you're missing from that assessment is, how is the student functioning right now in this classroom that they're in? And if they're not in a classroom yet, we don't know, where they're at. And some school assessments, if the child is 3 to 5, they may not be in a school setting either. So that makes it problematic. So we're going to look at that as being the reason why oftentimes schools are like, well, yes, you got a neuropsych to do this assessment, and it's very thorough. It might be 50 pages, but we haven't had this section in the school classroom. So we're missing a piece. So they are entitled to do their own assessment. So if you come to them and say, here's my assessment, sure, they can say, we're going to accept it. We're going to use it as our own, create an IEP.
Yeah.
But they don't have to do that. They can certainly say, we want to assess. So, a lot of times the most typical, situation is that a parent comes to a school district, says that there's something going on. They have a suspicion of a disability. The district does an assessment. Maybe we need more information. So the parent either asks for the district to fund, or they privately fund, an independent assessment with a private assessor. But before we even get there, in terms of tips when you first initiate, the biggest thing we can say is put everything in writing. Because more often than not, conversations happen at pickup, at drop off, in exchanges, and they never go anywhere. Because we're all human, right? If we don't, I have 20 notes a day on my reminders list of things I need to remember, because I've got an 18-month-old that's grabbing my arm half the day, right? So I have to have things written down. So the same goes for school employees. They may mean well, and they want to make sure that the administrators get your request for an assessment, but if it's not in writing, there's not often as often that follow through. So if you're making a request for an assessment, if you're just having a conversation saying, I think my kid's struggling, I think we need to look at some things, put it in writing.
Shoot an email. Just shoot an email. Text, sometimes we get lost in our text messages. And then sometimes with the school loop or the portals, you may not be able to access certain things. So send an email. Get the teacher on there, maybe the principal. Just be sure that it is in writing. You don't have to write a letter, but if you like to, that's totally fine too. Just get a copy of it.
To interject, we have this scenario where, for my son, we had a meeting with the school. We don't even know what we're supposed to be doing. We did TK on Zoom.
Okay.
And then I sent emails. I spent so much time looking up the right people, trying to figure out what the district number was, phone calls, no return calls, sending out emails when are we meeting? Because I guess we need to know who's watching his blood sugar.
Right.
And that's when I end up contacting you, because I wasn't getting any response. So you're saying what's most important is get the email out there, and then you might, even if it's not the right person, but it's somebody in the school, or is it key that you have the principal on there or somebody who knows how to direct it?
The way that the law works is that if you talk to a teacher, if you talk to technically anybody at the school and say, I'm suspecting that my child is struggling, if they have a disability, I'm suspecting something and I need help. That person you're talking to has an obligation technically to make sure that that request goes to the right person. So if that right person needs to be the principal, needs to be the school psychologist, they have an obligation to do so. But not all school employees are trained on this protocol and the procedure. So when you are emailing, especially for the first time, it's important to have multiple people on. So your teacher is the first point of contact usually, then the principal or some administrator at your school. But even more important than that is someone from the district. So if you have to go on your district website to find out who's the director of special education, who is an administrator, even the superintendent is fine. Usually those email addresses are on their website. So email as many people as you feel necessary, because oftentimes there is that strength in numbers that, if it slips through the cracks of one person or two people, it's less likely to slip through the cracks of 3, 4, or 5. Obviously, we don't want to be bombarding every single email that we have from the district, but those are the most important people that you can probably put on that email chain. If there's a school psychologist for your school and you get that contact information, that's good too, because these are people who can evaluate, okay, this is a request that seems like it is important. Now, the caveat, and where I think parents get tripped up, and where we saw it with you and we see it with a lot of parents, is a parent will do the right thing, right? They will email and say, I think we need to get started on this. But the school team says, we've got it under control. We'll ask. And they ask an administrator, maybe it starts going down that line, but then somewhere down the line, someone says, oh yeah, we'll take care of it. No big deal. Like, we don't need to go through the IEP process. Or they go to the teacher and say, hey, do you think that we need to do an assessment? And a general education teacher isn't often going to know when an assessment is needed. So they may say, well, I'm handling it, I'm fine, right? Because they don't know any better. And that's where it gets tripped up, because then the administrator hears, we don't need an assessment. Mm-hmm. And they don't always follow back up with the parent to say, this is where we're at. So the second best tip that we can give as a parent is trust your gut, right? You weren't getting the feedback that you needed. And so you went the step further and you got help and you trusted your gut. You knew that something more needed to occur. Parents often second guess themselves because they think, well, this school, they have the best interest of my child and they would do the right thing. And I'm not saying that they're not doing the right thing all the time, but they don't always follow the protocol, right? That's why we have our jobs exist. So,
yeah, I think Amanda and I are operating from the worst case scenario. That is what all of our experience is for the parent, right? Obviously, we've worked with a lot of great people, and I don't want people hearing this to automatically just start emailing all these people. I think a good place to start is the teacher and the principal, especially if you have concerns with the special education aspect of it. Once somebody ignores you or doesn't, get back to you, then maybe the school psychologist. Like, you're not starting with the 10 people right at the onset. We're all human. There are a lot of things happening. We are still living in a pandemic. But the more time that does pass, the more potentially that your child is not getting the services that they need. So we just want it to be known that, if the teacher is not being responsive, go ahead and kick it up a notch, right? And getting those people involved.
But I want to
ask, the other scenario is you might get a response, but the response is, we talk to the teacher or we talk to people and we just don't think an assessment is necessary. That's also where you trust your gut. If you think, no, I really do think an assessment is necessary, that may be where you need to, call upon an administrator of some sort, because the district does have an obligation to assess, even if it's just you that has a suspicion of a disability. It doesn't have to be everybody agrees that there's a problem. You are a member of the IEP team as a parent.
So I want to ask, you said just, let anyone at the school know that there's a concern. But if you tell them I'm concerned my kid is not focused, that might not be enough, correct? Like, isn't there some sort of specific concern you have to intimate and make clear? As
so the wording that we've used, the suspicion of a disability, what you've just said there is, I'm concerned about their focus, their attention. That's a suspicion of a disability. But a general education teacher, sometimes even administrators, they may only have general education credentials. So they're not trained in special education the way that we would like them to be. So do they understand that attention and focus could be ADHD, could be some other underlying specific learning disability? They may not know. They may not be thinking about the greater impact. So if you are able as a parent to say more, like, I believe my child's education is being impacted. I believe my child may need an IEP. I believe my child needs to be assessed for an IEP, needs to determine eligibility. This terminology are all triggers that are stronger than just saying my child is struggling. So while you shouldn't need to use this language, it's often better to use this language. You're more likely to catch the attention of the school psychologist.
Descriptors, and give an example. I'm concerned about his focus, period. When we're reading at night, he can't seem to tell me what we just read. Today at school, he told me this. The teacher has mentioned that he's losing focus. Like, those types of things, kind of these examples, right, that you're able to kind of pull together. Because although that should be enough, absolutely, 100%, it's not. Because all second grade boys are like that. They don't have attention. I'm the teacher. I can, and it's just like, okay, cool. This is my child. I know my child. So let's talk a little bit about it.
Or you may have a wonderful teacher, right? And wonderful teachers still may have students that need IEPs, because as wonderful as your teacher may be, they have limitations. If a child needs specialized instruction that is outside of the classroom, that is one-on-one, no matter how wonderful that teacher is, they may not be able to provide it. So where we get wrapped up a lot of times is the teacher says, I absolutely understand what you're saying. I see it too. Here's what I'm going to do in the classroom to try to help this student. And as well-meaning as that is, it doesn't help if something happens to that teacher, if what they're providing just isn't enough, if that teacher leaves, what happens next year, right? We're not documenting the support that child may be getting from that teacher. And again, it just may not be enough. And so we get that a lot, where the parent and the teacher may be having conversations every day and seem like they're working through, they're brainstorming. Maybe the parent sees tools and tips on Instagram and they're like, can you introduce this? And the teacher says, yeah, I have no problem. And it seems like we're working through the issue, right? And it seems like we're getting the help that we need, but it's likely not enough because we haven't initiated that IEP process. So it's almost like where you tell the teacher, I'm so happy that you're willing to do all of these things. This is great for the meantime. Let's still get the IEP initiated, because I want to make sure that next year they're supported, right? Because we don't want the teacher to feel like you're still not doing your job, because they are doing what they can do. But a school psychologist has different training than a gen ed teacher.
And so once you get that IEP, you're going to have your first meeting. You get an IEP meeting notice. So it's a mutually agreeable time and place. I bring this up because now we are in a different realm. So if a mutually agreeable time and place, usually we're just like, oh, time, like you have to make it work for these working parents, this and another thing. What I love to point out now is that place can actually be via Zoom. We all know that we can do it now. And how much more convenient is it for a parent to say, I'm taking a 2-hour lunch, I'm going to shut my door and I'm going to be here, go in their car, whatever, rather than take the entire day off from work, because that's probably, 9 times out of 10, what our parents have to do for a 2-hour, maybe hour and a half IEP meeting. So that's something else that I want people to know, that it's a mutually agreeable time and place. So if they give you one date and that doesn't work for you, you say, that doesn't work, I need another date. Once you have a date and time that works for you and you go to sign that IEP meeting notice, right under your signature, there's usually a little bit of space, always on the front, don't ever do it on the back. Right, I will record the IEP meeting. All of us have our cell phones. All of us can do the recording on our cell phones at the very least. And that's just nice, because if you have a partner, you have a spouse that's not able to go, you can take a beat. You don't have to sign anything at the IEP meeting. Another tip, right? You can digest the information and you can listen back and you can have a conversation with your spouse about what happened at the IEP meeting. And if they have any questions, maybe you have a part 2. But that is something, it's in writing. You have to provide it 24 hours before the IEP meeting in writing that you are going to record. You're going to get the IEP meeting notice a couple weeks before. Just jot it down there. If not, send that email and say, hey, I'm going to be recording. If you record, the district has their opportunity to record. In this realm of video, we only audio record. We've gotten into some issue. I don't want it video recorded anyway, but we've had some districts say, oh, well, you know, and it's just like, that's fine, whatever. I'm just going to audio record. So that's another great tip that we give to parents as well.
Yeah, and you don't have to get their permission. So in the state of California, technically you have to get permission to audio record another person. This is the one exception because the IDEA, the Individual Disabilities Education Act, is a federal law. It supersedes this. It says that in IEP's meetings, parents have a right to record no matter what. So if the school comes back and says, yeah, no, we don't want you recording, they can't say that. You do have a right to record. So the notice that Vickie just mentioned is just giving them notice. I'm going to do it. It's not asking for permission.
Interesting. I want to go back 2 points. Also, do talk to your pediatrician if you think there's a concern. I think it helps when you can go to the teacher and say, I was telling my pediatrician about these developmental milestones and I was worried. And she said, oh, definitely we need to get that assessed and to talk to you. I don't think your pediatrician's going to care if you even make it up, because early intervention, if you're worried and you're not comfortable for some reason, like you feel a little bit bullied at the school, definitely say, my doctor's worried. I wanted to get an assessment. And isn't it true that there's a short time frame? Like they have 14 days to reply?
In the state of California, yes, it's 15 days that they have to provide you with a response to any request. So whether it's asking for an IEP meeting, asking for an assessment, asking for a change in your IEP, the school has 15 days. Under the federal law, the timeline for like other states outside of California is what's reasonable. 30 days may be reasonable in some areas. 75 is not, So yes, there are timelines. The school can't just push things off. So, when you're looking at, I've made the request, I haven't heard back. I wouldn't necessarily wait the 15 days. Because now in the time of email, you really should be getting a response before 15 days. So it's not outside of the norm for you to follow up in like 5 days, 3 days to say, hey, just wanted to make sure that somebody got this. But certainly the school district needs to respond within 15 days. And that could be giving you an assessment plan, or giving you what's called a prior written notice, which is a letter from the district saying yes or no to your request. So this goes to any request that you might make. But if there is a suspicion of a disability, that response should be an assessment plan.
Okay.
And
do you have any other tips? I interrupted your flow.
Yeah, no, it's okay. Just kind of going off of the timeline, especially here in California. So once the parent gets the assessment plan, the parent has 15 days to mull it over, maybe, talk to their pediatrician, because if they don't check mark every single box, which they should for an initial, because you're trying to figure out what the child needs help in, maybe they didn't check off occupational therapy. You can say, I have suspicions in occupational therapy as well, these fine motor skills that we're not seeing. And then they should provide you with a new one and check marked. If they don't, then they have 10 days to write their prior written notice as to say why. All that is to say that once you sign it and return things like that, or just like turning it in at the office, but getting a copy, maybe time stamped, that you turned it in to whoever at the front desk, because
and save a copy for yourself.
Right. Time stamp for yourself. I think that that's important because as we are in April, essentially, right, we are getting to the end of the school year. For some schools, today or tomorrow, we got 61 days. So we can most definitely have assessments. We can definitely have the IEP meeting, and let's get a plan together before the start of next year. However, as the school year goes, and if we're, definitely if you have a feeling it's May, school's out May 30th, just request it.
You'll do it.
Just still do it, because the timeline will start. And because there is a break in excess, I believe it's 5 days in California, then, because of summer, some districts may choose to assess over the summer. We've had that happen. They most likely won't, but they'll pick it up in the new school year. And that may be a difference of having that IEP meeting end of September, and they started September 1. And then you have, oh, great, we have an IEP for the rest of the year. That can make the difference of starting September 1, them not being done all of September, all of October, right? You're having an IEP at the end of October. Then we're in Thanksgiving. Then it's Christmas. We just lost a whole semester, right? So that's why we talk about timelines to people. Obviously, this is so much information, and we don't mean to bombard people, but we just want them to know that there is a procedure, and it's very specific in California. And if you ever have questions, you ask them in writing again, because that's exhibit A for us, that you ask these questions and, they weren't being forthright with you or whatnot, right? But most of the time they are, and they'll kind of give you the basics of things. One other thing I would want to mention is if your significant other can't come, bring a friend to the IEP meeting. We are talking about our children, and we are mama bears, and we get very protective of our children. So having a friend there that can take notes or just be another set of ears to hear things is really helpful. Amanda and I, we'll be in presentations, and we'll be like, did you hear this? And she's like, no, I heard this. And, and that's just like the two of us doing we do the same area of the law, but we're two different people. Right? So and
often because, the parent walks into the meeting with, these are the two things that are most important for me. I need to ask these two questions. I need to make sure these two things get put in the IEP. So you're hyper focused on that. But what the team might bring up is 3 other things that you didn't even think about. And you want to make sure you don't miss those. So an extra set of ears of that. And you know what? The recording, if you can't bring someone, the recording serves as that role, because you can go home and you can listen to it too. So don't feel like, oh my gosh, I don't have anyone that can come with me. You have that recording as an option as well.
And is the timeline true for the 504 or just the IEP?
504s are different. So the law is a lot more loosey-goosey. They have reasonable timelines. It's not the strict 15 days, the strict 60 days. There's not even really a set requirement for assessments. 504 plans, they should be done based on an assessment, but oftentimes they're not. It's informal.
We've had some kiddos get it just based on the medical documentation that's provided. So like extra time on tests, time and a half. Maybe they needed 2 or 3 extra days. Sometimes the team just gets together and they just put it down in the plan. And then it really is, if the parent reviews it, sometimes, they'll review it a year later, but more often than not, the parent has to initiate it. Because like Amanda said, they don't have to come together a year from now, right? It's
all, there's just not as many rights.
Some are good. Yeah, some districts are good. Some have 504 coordinators. That's all they do, but not all of them have that.
All right. Well, are we okay moving to our last topic?
Yeah.
Because we've segued nicely there. What are some scenarios where you might recommend, I don't know if it's fair to say but some common scenarios where people should seek legal counsel in the school system?
I mean, again, I'm going to say trust your gut if you feel like something's off. So this is applying to when you're trying to communicate, right? And you feel like it's been a long time since you haven't gotten an answer, or you feel like you've asked 10 times and you haven't gotten an answer, or you keep getting the brush off, right? But it also applies to when you're in the IEP. Maybe you've had an IEP for 5 years and your gut is telling you that what they've been doing for behavioral support for 5 years has done nothing. Trust that gut. You may think maybe they're doing okay, but there's something in your gut that is telling you that something's just not right. You may not know exactly what it is, But generally, an attorney, someone who's specialized in the field of special education, can review your child's records and tell you, you know what, that gut feeling, this is what it is. Because that's what we're trained for. We see IEPs every day. We can generally spot a problem a mile away. When families come to us, a lot of times when we draft complaints, they come to us with 1, 2, maybe 3 issues. And then we write a complaint, and the next thing we know, they're just like, I didn't know about 15 of these other things that you said. So I think your gut is such a good tool. I mean, we say mom gut for everything as a parent, but I think it applies to schools too.
Got it. What are some other tips? I don't know if I kicked Vickie off, so I'm going to go send her the link again.
So if you've made requests for things over and over and you're not getting, so for example, you've asked for a service that you've never had, right? So you think all of a sudden occupational therapy is a need, or physical therapy is a need, or maybe you just got diagnosed with dyslexia and forever you've had an IEP, but this is something new. And you tell the school district this new information or this new suspicion, this new concern, and they're saying, yeah, we don't really see it. If they don't come back with, you know what, either A, let's do an IEP to talk about it and change the IEP, or B, let's do an assessment, then there's probably an issue there. Because just like with the initial assessment, a suspicion of a disability or a suspicion of an issue is enough to do an assessment. The same applies for later on, right? Even if you've had an IEP for 2, 3, 5, even 10 years, something new pops up, an assessment really should be done. So a lot of times when parents come to us, the concerns that they have never been assessed. And so when we look at their records, we often see that they're going through this back and forth conversation about whether or not something is a concern and whether or not that concern is impacting the education of the child, but they've never had an assessment on that. And so that back and forth is never going to get you anywhere. And the school may not really realize that this is something that needs to be added to the assessment. So I'd say more often than not, the need for a new assessment, a more thorough assessment, or additional assessments is where you're going to get the new or different services that you need. So I think that's one of the biggest times you might come to an attorney. The other is when you're being denied an IEP in the first place, because most of the time, if there's a suspicion, there's a very high likelihood that your child should be eligible for an IEP, if not at least a 504. And if you're being denied and you repeatedly being denied, you should seek the help of an attorney, because that denial is not going to change overnight. Getting a new teacher may change things the following year, but then you're delaying it another year. We only have a 2-year statute of limitations across the country under the federal law. So time is of the essence. And your child's education is of the essence, right? They may have from 3 to 22 that they're in this system, but every year is important. And so we don't want to waste time. So if you just feel like something's taking too long.
And then your model, I don't know if it's the same across the board for other legal counsel, but you are able to be in the background and help people navigate if they don't want to be litigious at first, but they don't know what their rights are or don't know how to start the process. And it's a reduced fee. And I assume with your nonprofit, you're able to help out people of all incomes.
Yep.
Can you explain that model in case people aren't aware that they could get help without looking like they're about to sue the school?
Absolutely. So our model is a little different than most. Most here in California do charge for filing of a complaint. And that can range. Some of the LA firms charge minimum $10,000, where it's a pretty penny. So Amanda and I, with the nonprofit, really wanted to be able to provide as much access to these advocacy services. And while the federal law does indicate that if you file a complaint, an award of attorney's fees can be provided, as a business person, most attorneys want that money up front. So what Amanda and I try to do is when you call in for doing a general intake with our paralegal, Lauren, one of the questions that she'll ask is what your household income is and how many people are in the household. And really, we do that so that we're able to, we go by the federal poverty guidelines. So if you are a family of four and you make, $50,000, you're more likely than not able to get our services of the filing of a complaint for free, because we're hoping to get that award of attorney's fees when we win the case. If you are a little bit above what we call it low bono, so it's not free, it's not pro bono, but we ask for a little bit upfront from the parents. So instead of that $10,000 for the filing of a complaint, maybe it's $2,500, maybe it's $3,000. Depends on the district, depends on the issues, and depends on what it is that you're looking for. So the filing of a complaint is one aspect. And then we have this yearly care maintenance package that we like to call it. So where we're your attorney for the year. And that can just manifest into a lot of different things. It can, what you're talking about, Dr. Vivi, where we're kind of in the background, we're kind of like giving you, letters to write or provide you the letters with. We're reviewing things. Maybe you want to kick it up a notch and we're your friend that comes to the IEP meetings. I mean, obviously we're your attorney, but we're your friend, right? On your side. Sometimes we do all the talking. Sometimes we don't do any of the talking, depending on what it is that you're looking for. Maybe we just go to IEP meetings. Amanda has had clients, I've had clients since we started our law firm, 10 years, where we just go every year, right? And we just make sure we're the watch keepers, right? Where we make sure everything's on track. Sometimes we just go to IEP meetings. Sometimes we go to IEP meetings and then we file. So we have a really flexible way of providing our services. And that's what we discuss. So after you do the intake, then we do a consultation. And that's what you're really discussing with Amanda and I. But through our nonprofit, thankfully, we're able to fundraise and we are able to provide so much of that advocacy for our low income families, which has been wonderful. Go ahead, Amanda.
Yeah, no, I was just saying, and there are some attorneys that do provide advocacy, say at the IEP meetings, and that sort of thing. I'm not aware of any others that provide like year long. Most of the other firms that provide representation at IEP meetings, they do charge by the hour. So, I mean, they may charge a $5,000 retainer and, they're on retainer until that retainer is up. So that might take you to a year. It just depends on how much work is needed. But I do know that is something that does have us be a little bit different from other firms. And of course, being the nonprofit, we are able to provide the low cost and free services for those who do qualify.
It's really a beautiful gift to give these families. And as a pediatrician, I can't emphasize that early intervention is the key to success, making sure your child's happy at school. If your kid's not happy at school, something's wrong. And
Yep.
what I see as a pediatrician is they don't diagnose dyslexia or dyscalculia or dysgraphia or other learning disabilities in the classroom because a smart kid can hide it until middle school. So
Really,
trusting
yeah.
your gut, I think, is our take-home point here.
Yeah,
Yep.
absolutely.
Any closing points? If you have any charities coming up, I'm sharing your website. It looks like you've transitioned fully over here for people who want to learn more, or the podcast I shared on the screen. I'll send some links to right now. Anything you want to any closing remarks?
I would just say, if you're looking for more information, our Instagram and our Facebook is a great resource. We're constantly providing resources, both free and otherwise, not just locally in here in California, but all across the nation of services. We try to share a lot of resources of like other pages and other, say, therapists and organizations that help the demographic. Our goal as a nonprofit isn't just to provide the legal aid, but really to connect people and get the families the resources and the education that they need to advocate for their child, their entire lifetime. So we do have groups we partner with that help students who, are older, and younger, the early intervention. So I think that that's a great resource. We do have a Facebook group that is kind of linked to our podcast where parents go and can kind of continue that conversation with each other, because as parents, the best resources you have are other parents typically. So we think that's an important thing to find a good network.
Yeah, and I would just say, as a parent, you're doing the best that you can with the information that you have. and you're not going to know everything, and that's okay. And as Amanda said, that Facebook group, that sense of community, we're not meant to raise children on our own. That's why we have the saying, it takes a village. So, be open to that, I think is important as well.
Well,
Yep.
thank you guys so much. You guys have a wonderful day.
Thank
And
you.
Thank
hopefully we'll
you.
do this again. Bye-bye.
Yes.
Bye.
Bye.